examinations. Therefore, selection if is done in a written test, you are not allowed to have test. Supreme Court said, no, you cannot do that because in the advertisement you issued inviting admission, you have nowhere stated that we shall not admit anybody having vision difficulty. Please see me, Lord, paragraph 12 of this judgment. That is one reason given.
Yes.
Paragraph 12.
Mm.
In our view and in view of the discussions made here in earlier, in the Paxton's case, Article 14 was infringed for denial of permission to the petitioner to sit and write the examination for selection of probationary officer. As noted here in earlier, this petitioner was not allowed to sit for the competitive examination for the post of bank probationary officer on the ground that she was a visually impaired candidate. Although the advertisement in the newspaper did not disclose that a visual impaired candidate sit and write the examination, as the nature and duty of the job were not suitable for the visually impaired candidate. It was not mentioned. It is not in dispute that writ petitioner had qualification officer as per the advertisement. Statement has been made in the writ petition by the writ petitioner to effect the writ petitioner, like other visually impaired persons, can perfectly perform the job of a probationary officer. He also applied for the same post to BCRB and received her admit card for the same. Thus, there is discrimination, responding between, etc. This is one ground. And then another ground you have to find paragraph 11. Please come to paragraph, which is not I rely upon. Lot of things are said, equality, equality. What is equality? So, but therefore, this case has no application, no relevancy, except without the legal principle laid down by Supreme Court in paragraph 11. What is equality? Paragraph 11. Taking our finding as made to the extent that the petitioner was entitled to sit and write the examination for selection of probation officer in the bank, let us now proceed to consider whether writ petitioner would be entitled to appointment in the post of probation officer of the bank in question, if successful in the written examination. In view of the nature of the job to be performed as probation officer, again, the nexus theory comes in. Whether this job can be performed by a person with a blind. Before we deal with the aspect of the matter, we may take into consideration yet another aspect of the matter, namely whether denial of permission to writ petitioner to sit and where the examination for the post of probation officer in the bank office offence, Article 14 or 16 of the Constitution. This is the question. Article 14 of the Constitution guarantees to every citizen of India a right to equality before the law, or the equal protection of law. What does it mean? The first expression, equality before the law, which is taken from the English common law, is a declaration of equality of all persons within the territory of India, implying thereby the absence of any special privilege in favor of any individual. Now, it also means, this is important, that among the equals, the law should be equal among the equal and should be equally administered, and that like should be treated alike. Thus, between persons who are substantial in similar circumstances or conditions, it does not forbid different treatment of unequals. Article 14 has both negative and positive. That's why I took the pain of submitting my lordship. Why these untainted candidates and the fresh applicants are not equals? I submitted that we have these unequals have already passed one selection test, but and also served in there as a teacher. But they became subsequently discovered to be victim of circumstances. They are victim of circumstances. The other fresh people, they had not appeared in any selection test, had not passed any selection test. Our case is these unequals, untainted are already held to be competent to be teacher by competitive examination. Examination. Let the marking is also maybe. So, my lord, they should not as an unequals. There, there, and Supreme Court itself has made a different classification for untainted. Similar, they are not to be equal. Article 14 is confined to treating equals are treated unequally. And also at the same time say unequals cannot be treated equally. This is not equality principle. I rely upon the judgment for this proposition. And there are many judgments that Lordship is aware must be that unequal, if unequals are treated equally, then is validity of Article 14. But I did not cite because this judgment they have themselves cited. Next judgment cited is Supreme Court ultimately found on expenditure probationary officer's job can be discharged by a person who is visually impaired. But Supreme Court said no. That allow her to cite in a written test, then proceed according to law. Yes. Now, next judgment cited, my lord, is 2025 SCC Online 1009.
Copy devo, sir.
Huh?
You'll be adding up copies. I want to see. It must be here. What is the name?
Samim Ahmed.
Sagid Ahmed. Yes, Ms. Sagid Ahmed will have this.
Give this
2025
SCC Online.
2025 2025 SCC Online 1009. Name of the case is S. Ranjit Singh and others versus State of Tamil Nadu.
Yes.
State of Tamil Nadu. Here read some paragraph 19 relied upon.
Which page did you mention? Which page did you mention?
Page of SCC Online is 1009.
All right. Yes.
If it's not easily traceable in the compendium,
Sir,
I can give a copy then.
No, you read, I can follow. You read, I can follow. No issues.
Yes.
No issues. You read, I follow.
Kindly see paragraph 6 of the judgment, which should have been placed. That will indicate the nature of controversy. Paragraph 6 at page. Notification এই paragraph page গুলো গেল notification করতে করতে 6. This is without facts of the case reveal that constables working in the police department in the year 1995 were given 20% of the vacancies to compete under the direct recruitment quota. And they were to be given seniority over and above the other 80% remaining constable recruited through open market. So, there's constables at a vacancy for constables. Now, out of that, 20% was taken out for allowing not the direct recruits. Direct recruits vacancy was 100%. Out of that, 20% being carved out for departmental candidates, already employed. Not only that, it also provided that departmental candidates who are successful, they will be placed in the seniority list over the new candidates, fresh candidates. That was subject of challenge. Seniority was became not paragraph 15. Supreme Court said, what is a dispute involved? I beat paragraph, third paragraph, that phrase 9. The dispute involved in the present case is fixation of inter-C seniority in respect of direct recruitment, which includes some in-service candidates also. Sorry, sorry, I made a wrong reading and didn't comma full stop. Dispute involved in the present case is fixation of inter-C seniority in respect of direct recruitment, which includes some in-service candidates also recruited under direct recruitment quota. The 1955 rules provide that recruitment to the post of sub-inspectors of police by way of direct recruitment and by a promotion. Rule 3 quoted, etc., is quoted then going on. Then ultimately, my lord, the Supreme Court notes that the rule did not provide for giving such seniority. It was being done under executive order. Then government has been doing so for quite some time. Then government realized the mistake. It's a mistake. So they framed the rule, amended the rule with retrospective effect in 1955. And that was subject matter of challenge before Supreme Court. Then paragraph 16 I'm reading. The state government finally realizing its mistake issued GO number such and such on 21/11/2017, which is subject matter of the present appeals, reserving 20% of the vacancies for service police personnel and 80% vacancies for open market candidates for the post of sub-inspector police, and also for providing seniority to the in-service candidates en bloc over and above the candidates appointed in service by way of direct recruitment under 80% vacancy. This is the issue. Now, what Supreme Court says, the reason that retrospective amendment with effect of 1955 is violative of Article 14. That is the first head. Then next is when the Supreme Court, next down is that when you give those seniority, there's no rule permitting you to do that. But rule is contrary. And only relied on executive instruction. So question is whether executive instructions, orders, can supplant rules. That is paragraph 22, the main reasoning 22. It cannot supplant. Paragraph 22. Oh, sorry, may I read paragraph 19 also, that short line. Paragraph 19, my lord, also. 19, my lord. That 19, it exactly this point. 19, my lord, I'm omitting counsel's submission, I'm omitting. Then I'm reading in the last of that page, it is at page 19 of the SSC online. I'm reading the second part of this paragraph 19. In the opinion, in the considered opinion of this court, I'm reading that part. Such an action on the part of the respondent state is against the settled canon of law. The canon of law rule, that is Rule 25, was very clear, which provided for fixation of seniority with reference to the rank assigned by the appointing authority in the list of selected candidates. It is unfortunate that state government has amended Rule 25 by GO dated 21/11/2007 by giving a retrospective effect, that is with effect from 13 July 1995. That was given. The state government has certainly issued various executive directions from time to time for appointment under direct recruitment quota, providing reservation to in-service candidates to the extent of 20%. However, the rules were never amended until 21/11/2017. It is a well settled, that proposition of law that executive instructions cannot supplant the statutory rules. They can supplement, clarify the statutory rules. In the present case, executive instructions issued from time to time have in fact supplanted the statutory rules, and such a process is unheard of in the field of service regulation. This is a point involved, which is not involved in our case. In this case, there is no such point involved. Executive instruction, supplant, no. Therefore, it is not really relevant judgment to that extent. Then, that doesn't extend. The judgment is quoted, I'm not reading that. Then judgments are quoted in support of this proposition. Then paragraph 22 of the judgment. State government, without amending the recruitment rules, right from the 1955, continued with this appointing process under the direct recruitment category by appointing in-service candidates, and in the considered opinion of this court, such a recourse was not available to the state government without amending the recruitment rules. However, in the light of the facts that the persons have been promoted, this is not relevant for my lord in this case. However, that those appointments are bad, illegal. However, in the 1995 and thereafter also, this court promotion orders. The state government, without amending recruitment rules till to 2017, continued to appoint sub-inspectors of police from head constable serving the police department, and all such recruitments were made without amending the recruitment rules. The recruitment rules were amended only in the year 2017. In the considered opinion of this court, the amendment to the recruitment rules in the year 2017 is to the extent it provides for 20% reservation under the direct recruitment category, to the in-service candidate, does not warrant any interference. Reservation cutting it, that it doesn't know, court did not interfere. However, the amendment brought by geo-dated 21/11/77, amending Rule 25A of the 1955 rules, which provide the grant of seniority to all in-service candidates over and above the candidates recruited from the open market, is certainly violative of Article 14 and 21 Constitution and deserve to be. Then retrospective effect, paragraph 20 deals with that. That is bad. Well, I am humbly pointing out these judgments, although the promotions or seniority given since 1955 up to 2017, illegal, contrary rules, the court did not interfere with that. Those promotees were not demoted. Maintain what has happened, because they are not, again, that this point comes here. The innocent parties should not be made to suffer. If they're party to the fraud, then that party should be made to suffer. Therefore, Supreme Court did not interfere with the promotions already granted. And the question of allowing 20% reservation, the rule was upheld, but not the retrospective effect. That is not. But although it did not do so, Supreme Court maintained the so-called, we call it illegality in the matter of promotion, because they have already been de facto appointed, serve in that post. That was not disturbed. Similarly, in this case also, Supreme Court took the similar view that those untendered candidates who passed the examination successfully their service has to be terminated because of the genesis of illegal practice and cancelled. So, next has been cited is 2005 SCC online. 2025, not 2025 SCC online 2119. It was tender matter.
Yes.
It was tender matter. Pay attention, sir. It says before Justice Sanjay Kumar, आता ही बता कि उसने क्या रह जाता है. Judge name doesn't matter. That it was tender matter. Tender grant of award has been considered to be a grant of largesse. But giving appointment to the teacher is not largesse. It is their right upon successful competition. Therefore, the principles of tender matters should not be applied when it's a case of appointment of teachers in competitive examination. This is number don't apply. Secondly, my lord, in tender matter, Article 19 is relevant. 119, yes, relevant. And that is the right to carry on business. That is not applicable in the matter of appointment of teachers. Article 16 is 16 applicable, not 19. Therefore, one may cite, let them, I don't object to that. But it is relevance smart. What was happening in this case? Condition number 4 of the tender condition was challenged, ultimately challenged. 4 conditions were challenged, but 3 of them were deleted by the tendering authority. Only condition of 4 remain. And what is condition number 4? My lord, find that in paragraph 8. Paragraph 8. During the pendency of petition, corrigendum, later census, 1, 11, and 12 were deleted. Division bench of the High Court by a common order dated 11 August, issued in civil matters, and by an order dated census, passed the petition number up to, inter alia held that the impugned eligibility condition, namely condition number 4, with regard to past performance, is of similar nature and purpose as the condition in association of registration place versus Union of India. It was further held the respondent had demonstrated that the impugned tender condition is not unique into the state of Chhattisgarh, but a prevalent in the other states such as Gujarat, Assam, Delhi, Odisha, and Jharkhand. It was further found High Court a contract containing similar condition was awarded to appellant in the state of Jharkhand. Then High Court repealed the challenge to the impugned tender condition on the ground of discrimination and that was repealed by the High Court. Now, then submission of parties are noted that then analysis starts from paragraph 13. There the condition number 4 is quoted. Paragraph 13 quoted. Past performance on restriction. Bidders must have supplied sports goods worth at least rupees 6 crores to the state government agencies of Chhattisgarh in the last 3 financial years. Now, the Chief Minister of Supreme Court analysis that must have supplied sports goods worth rupees 6 crores. 6 crores Supreme Court did not interpret. That is the wisdom. But to the state government agencies of the Chhattisgarh only. There, the objection clinch. Then no nexus. Supreme Court says, yes, sports goods, object and purpose is to get good quality of goods. Therefore, you might have said 6 crores worth of goods, similar goods have been supplied. But why If they supply to other states, that quality of maybe all right. Why you could say that only those who have supplied goods to Chhattisgarh have supplied good quality? So that is confining this condition number 4 to Chhattisgarh was held to be have no nexus with the object of securing good quality goods. Same, this confinement, that's why repeatedly I submitted. If the state government, in this case state, that the teaching experience in state government school in West Bengal alone, then I would have said, why not? I might have acquired teaching experience from the other state governments, other governments, including central government. Question of experience can be gathered. But that is not done by, thankfully, they have not done it. And now,
They
this,
have done this.
No.
They have.
they have, but
Yes.
rules do not say so.
Right. So
Hmm?
you think, because I am having matters where this has been done.
They have done wrongly, therefore they cannot rely on that. But it is all settled. Next question. If a law is wrongly interpreted and wrongly applied, does not affect the validity of the law.
In the application form that the candidates filled up, there was a column mentioned whether you have taught in government schools in the state of West Bengal. A specific column was there.
Yes.
It is there that the experience had to be mentioned.
Then there's that column should be bad,
স্যার
not the rules. Huh?
তারপরে ডিভিশন বেঞ্চে এসএসসি বলেছে যে সবাইকে দেবে
Oh,
সাবমিশন বিফোর দ্য ডিভিশন বেঞ্চ
আচ্ছা, এটা কি? এটা কার judgment পড়ছে?
এটা ডিভিশন বেঞ্চে এই ম্যাটারে অরুণিমার
But my learned junior points out. I'll come to that point. Let's first finish my first point. Wrong application of law. The format is fixed by the bureaucrats. Rule is framed by the government. If they've wrongly understood the rules and framed the format, that format is bad, but rule is not bad. That is Lordship knows, that is judgment to that effect. But
ওরা বলেছে যে সবাইকে দেবে কেন্দ্রীয়
if in the division when judgment was so mentioned, can we read paragraph 24?
So that means occasion arose where this had to be brought to court. It is not that the rule is there, government, which includes state, central government also, and the authority acted. It is not that. Candidates had to approach court and obtain order.
Yes, therefore it was corrected at the appropriate time before it started, corrected.
Anyway, you make your submission.
No,
but
that's right.
contrary
Therefore,
submissions also.
the conduct may be bad. And paragraph 24 of division when judgment reads like this, is a Bandyopadhyay justified the awarding of 10 marks for prior teaching experience. On the ground, it is also extended to teachers who are taught in schools under Kendriya Vidyalaya, Navodaya Vidyalaya Samiti, State Council of Education and Research and Training, etc. And other government-sponsored schools. Marks were provided with view to appointing teaching. So, but what the column may be there. Column to dictate away. But even then, the commission is making submission to court that this 10-mark teaching experience has been granted to those teachers who are taught in schools under Kendriya Vidyalaya, Sangathan Navodaya Vidyalaya Samiti, State Council of Education, Research and Training, and other government-sponsored schools. So that if the column is fitted, that is not being followed.
Yes.
That not followed. Now, Lordship is considering validity of a rule, legal validity of a rule, not on the rightful or correct interpretation made by the bureaucrats. If they're done, it has to be corrected. all those who have appointed with explanation made teaching experience in government school, they should be awarded. That can be corrected any time. And in fact, the government, when admits, even now I would say that whoever have teaching experience of the government schools, and not regardless of West Bengal or not, they will be awarded. They will be counted. That's enough. On that ground, rule cannot be violated. No, the judgment to that effect, judgment দেখে দিও তো এখানে আর্টিকেল 14 violation হলে পর যদি wrong interpretation or bully remark that it is held by the Supreme Court, not that the actions done under a wrong understanding of a law does not invalidate the law. This is settled law. I think Mr. Dhor will cite judgment. I am not. That is a settled piece of law. Now, Millard, kindly read paragraph 19 on which they relied upon. Sorry. The paragraph 16, I am reading. Judgment also speaks of paragraph 16. What is level playing ground? What is paragraph 16? The principle of non-discrimination is embodied in Article 14 of the Constitution. Article 14 has to be read in conjunction with the rights conferred by the other articles like 21 of the Constitution. Article 21, etc. Constitution refers to right to life, equal opportunity as well. Doctrine of level playing field is an important concept while construing Article 19(1)(g), which is not available, in our case, of the Constitution of India, Article 19(1), right. 19(1)(g) confers fundamental right to carry out business to a company. It is entitled to invoke the doctrine of level playing field, which is, however, subject to public interest. Number one, the doctrine of level playing field provides, it's important, the space within which equally placed competitors are allowed to bid. Equally placed. Paragraph 11 of the earlier judgment Supreme Court. Equally must be equally placed. Equally placed competitors are allowed to bid so as to subserve larger public interest. This is not what is meant by equal level playing field is mentioned in this judgment. Then, in paragraph 19, the reason given why it is bad, which is read out, a reason not to find, object of public procurement is secure, this is I agree, object of public procurement is secure equality goods and services for the benefit of the public exchequer. Said object can be achieved by requiring the bidders to demonstrate financial capacity, technical experience, and past performance in contracts of similar nature, regardless of the place of performance of the contract. To confine the eligibility to a participant to participate in the tender within one state is not only irrational, but is also disproportionate to the goal of ensuring effective delivery. This again means nexus. Confining that your performance, you must have supplied good only to the state of Chhattisgarh, and that's not good quality. It defeats it is disproportionate to the goal of ensuring effective delivery of sports kits. So disproportionate, it is do not achieve the purpose. Then paragraph 20, if I may there's one term. Such a restriction, however, cannot be justified as reasonable in the meaning of Article 19(6) of the Constitution. State, while it enjoys the freedom to prescribe the conditions of the tender, cannot exercise that power in a manner that infringes upon constitutional guarantee by closing the market to outsiders without just cause. The doctrine of level playing field, again, requires that gates of the competition be open to all who are equally placed. That is mean, equally placed. Level playing field for whom? For the person equally placed. That a feed may be given to others who are not equally placed. Now, in this case, it's a plus eligibility criteria. In our case, teaching experience is not eligibility criteria, not eligibility criteria. So gates are open to all candidates. In this case, gates were closed for candidates who had not supplied goods to Chhattisgarh government. It is not the case that unless you have teaching experience in the school, etc., you cannot apply. You cannot apply. You know, one with a full knowledge that if he does not have teaching experience in the government schools, he will not get 10 marks more. But in other 90 marks thing, he will get the full mark. Written test, academic qualification. You have taken the challenge. The freshers have taken the challenge. Best. Without 10 marks for teaching experience, we shall succeed. And I've shown to your Lordship, in fact, 9,000, more than 9,000 freshers have been mentioned in the interview list. 9,000. And what is the vacancy there? 20,000, no?
20,000.
I'm not sure. Maybe nearly 20,000.
No, 35,000. 35,000.
Oh, 35,000. 35,000. No,
only 11.
Total, 35,000. And untainted are 13,000 in all. So even if all the 13,000 become eligible for appointment, upon all marks being taken into account, they'll have more than 20,000 nearly open for them, vacant, open for them. When marks, the merit list will be published, it will not be confined to teaching experience. Written test marks, academic qualification mark, then lecture mark, lecture performance, and then teaching experience. So they took the challenge, and I support, and 9,000, more than 9,000 already included in it. So this is a case, and the midstream, they want to change the rule of the game. That is my humble objection. If selection process is cancelled, commission has nothing to lose. You'll again start the process, inviting tenders for supply of reels, tons of paper, inviting tenders for appointment of supplier of ink, the printing, etc. And huge could another, they will be placing the orders for what crores of that. They have nothing to suffer. But they'll again start a new selection process. And this time they may again contend. This time the tainted people can also attend, because second Supreme Court said not tainted to be allowed in second selection process. If I can have a third selection process, to that tainted will be also be allowed. And that question may be raised. Argument will go on. That point will go on for 5 years. Again, minimum 5 years. Again, go on. They have nothing to gain. But the commission's attitude, I do not know. But they nothing lose. But we have to fight for our own survival. That we have taken test twice already. Should I be subject to a third selection test? And that they have been teaching. So this judgment not have drawn it. The next judgment cited in 2011, 7 Supreme Court cases, 789, page 789. Here the question rule was seniority cum merit basis. Some 50% was for only on merit, balance 50% seniority, merit come seniority come merit. Now the question arises, this is the question I also yes request also consider. Seniority, why that should be given weightage at all? Seniority means what? Experience, nothing else. Why that weightage being given choosing a party with merits? So seniority, experience can be considered legally and lawfully in conjunction with the merit. Then written test, education qualification, etc. Therefore, no court has held that seniority is based on experience should not be is giving a wrongful advantage to the people who have served longer, who gathered experience. So this principle of allowing seniority experience to be counted while deciding the selection on merit and selection shows me not experience has been considered and accepted as a relevant consideration in the matter of, say, promotion. Then why not in the matter of appointment also? This is judgment law. This judgment I shall come to dealing with this judgment right now. This is 789, page 789. Paragraph 23.
Page 50.
Page 50. Yeah?
50.
Page 15, এটা
Yes, sir.
ঠিক আছে, but I not got it.
Yes.
This have been shown, that's why I'm reading it. Paragraph 23. The rule is set out in that in previous paragraph, wholly set out in the paragraph 18 of the judgment. But coming to paragraph 23. Another very important aspect of the rule is that merit and seniority merit are the only relevant criteria for promotion to various posts. The language of Rule 24.1 or Rule 79 does not allow for any ambiguity and clearly says that a list of the senior most persons who are eligible and qualified under the rule will be prepared. And from that list, promotion on the basis of seniority come merit, or on the basis of merit, 50% on basis that was there, to the classes of posts concerned will be made. Rule 24.6 of the Rules 79 further postulates that all other higher posts or higher categories of posts in the service shall be made on the basis of merit and on the basis of seniority, come merit, in the proportion of 50-50. 50-50. If upon merit alone candidates are not available, then selection by promotion on the basis of selection come merit may also be made, the same man rule. So, but if the balance 50, just 50% left for merit only, but then no candidates are available, then seniority rule can be applied also. What I'm humbly pointing out, my lord, the seniority, which is equivalent to experience, has been accepted by everybody as a relevant factor. Relevant factor is a, and so giving some credit for the experience is very reasonable and legal. But in this judgment, I don't cite it, the judgment support me. I do not know why. Anyway, I'm grateful on your side in that. His judgment also, my lord, same another thing, how schedule of a rule is to be read. Here, my lord, there are a lot of argument on schedule of a rule, on the interpretation. It comes. I'll deal with the paragraph 25-26. Since I'm reading the judgment, see, my lord, what is schedule, how to read a rule, how is schedule. Paragraph 25. The first and the foremost question that arises for consideration by this court is whether, merely by the amendment of Schedule 1 and the deletion of Schedule 2 of the rules, effect of the statutory provisions like Rule 6, 10, and 24, the substantive parts, etc., in other plain language, would then dilute it. Can it be argued that the amendment to the schedule then renders the statutory provisions inoperative? Paragraph 26. It is settled principle of law that the schedule of the rules has to be in conformity with and is required to advance the object of the primary statutory provisions. Thus, a schedule cannot in any way wipe out the Statutory Provisions Act, and in effect, and the spirit, it is nobody's case, and in fact, nothing has been brought to our notice that Rule 6, 10, 11, 12, 14 of the rules have been subjected to any amendment by the competent authority. Once these provisions stand, etc. So, my humble servant also when it comes to interpretation, if the rule is held to be valid, then question arises whether it will be the teaching mark 10 will be given before interview schedule, etc. Then I shall similar their approach has been they have read the definition first and then the schedule, then substantive part, not that. Similar my submission I'll say that later on. What is definition clause? It is dictionary for the expressions used in the substantive part of the rule. I'll show you that. And schedule, what is that? Schedule is to advance the primary object of the rules. So schedule says in what order the marks will be given. And when I come to independent scholarship, schedule means in order marks to be given, and teaching experience mark to be given when that is in total conformity with substantive part of a rule. This is admin also assist your lordship to say how schedule, what the effect of schedule. The next judgment is 2024 13 SCC 241. This judgment, I don't know why it is cited. Anyway, cited. It tells it is in paragraph 37 has been read. Yes, is less down when the rules can be said to be altered by the Parent Act. On what grounds? That grounds have been met on paragraph 37. But in our case, nobody has argued in nobody's case the rules are altered by the Parent Act. Similar paragraph 37, I will only show you, Lordship. That's for my Lord's satisfaction. Paragraph, okay, page, this is paragraph 37, which has been read by my learned friend. Paragraph 8. It only clearly says below. From the reference to the precedents discussed above and taking an overall view of the instant matter, we proceed to distill and summarize the following legal principles that may be relevant in adjudicating cases where subordinate registration are challenged on the ground of being ultra vires the Parent Act. That is not so in this case. They are not grounds are given. So, but this judgment really has no relevance in our case. Next case cited, my lord, they have cited, that is the AIR 1986 Supreme Court, paragraph 4, which have dealt with earlier, my lord, paragraph 4. In this, what happened, my lord, the Tenancy Act, in our case, that the rent is so much amount, 1986, in Supreme Court cases.
That you have already distinguished.
Supreme Court cases have been given to your lordship. Then it
no, AIR is SSC is here.
86 SSC online.
And 1986 Supreme
Page 129.
Yes, Ratan Arya and others.
Yes.
Paragraph
State-
4 has been cited.
Right.
And this is equivalent to 86C Supreme Court cases. So I have read the Supreme Court
Yes.
thing. The case was the premises.
No, you have already distinguished this.
That is now making the point was the fixation of quantum or monthly rent for keeping that tendency within the ambit of statutory act or not. That is why that is relevant. In those days, earlier, 400 rupees rent or monthly rent was considered. Above that, will bring the tendency out of that tendency.
There was request.
And that supported judgment another. I don't deal with anymore. The last judgment of my learned friends are 2024 8 SCC 124. কোথায় গেল এটা? ও বই আছে, বইটাকে দাও। এটা কোথায় গেল? বইটা কে? বইটা, হ্যাঁ। 2024 8 SCC 124 at page 131 has been cited, has been shown to your lordship, paragraph 22.2. There not bonus marks were given to employees. Which employees? It is, my lord, kindly see the paragraph 22.2. It is administrative rule provided. Can you see question number 2? This is relevant. Paragraph questions for consideration. The answer, 2 questions arise for consideration are that candidate 22.2. Right? This is the question involved. Is the award of bonus marks to the project employed applicants discriminatory and ultraviolate the rules? Are the guidelines of such and such date sanctioning the award of bonus marks on a differential basis for applicants with project experience and other applicants invalid? Bonus marks were given on the basis of project experience. That was said. Supreme answer was no. It is valid. Answer also get that. I give the paragraph 47. Answer is given. It is valid. Yes, it is. Oh, sorry. Bonus mark. Paragraph 40 answer. But before that, Supreme Court discussed the matter. Before that, Supreme Court discussed the matter in paragraph 30.
31.
At question number 2, it starts. Page 135. Question number 2. Insofar as question 1 we weren't concerned with, so by the award of bonus mark is concerned, a careful perusal of the guidelines indicate it was issued before the advertisements, and all that is provided out of allotment maximum marks of 25 per experience. Ordinarily 2 marks are given. However, if the experience was the employment receiving honorarium on the project run by state government, then he was to be given 5 marks for each academic session with maximum 25 marks. Even if part of the experience was in project, extra marks were provided to all applicants. This is the then. In the application form, there is a specific column, namely column 14, which asked about details of the experience. The form, etc. Form is form is not important to your lordship, form is format. Then must please come to paragraph 33. Moreover, intrinsically, Rule 13.5, validity of which has been we have upheld. Evidence is available to show that rule recognizes the experience gathered from project work stood as a higher pedestal, on a higher pedestal, because it was in tune with the nature of the work of Prabodhak. Further, under Rule 25, committee was to prepare. I'm relying on this paragraph. That if this rule, our rule, put the untainted candidates who have served in the government schools for 6 they have been placed on a higher pedestal, that is not wrong. That is not malice. That is paragraph 33. And then judgments are quoted. Lots of judgments are quoted. paragraph, the no perversity in the criteria adopted. However, in this case, teaching experience was given a higher mark pedestal. And here in this case, same thing, the mark. Then this judgment really supports my case. Lordship, in paragraph 47 conclusion, we find no illegality in the prescription additional marks for those applicants who had experience of working in the projects. Paragraph 47. From all the judgments I've cited, I'm not given any judgment, will support my case that experience is a legitimate, relevant factor in the matter of selection of candidates.
All right.
Yes, now, Mrs. Dr. Guruswamy has relied on a judgment, many judgments. Actually, see that. It okay, 222.5 SCC, 225 SCC, paragraph. I only just give the reference. Huge compendium.
আর ব্লু কালারের একটা আছে।
Of judgment, I rely.
Which one?
Paragraph 20 Miller kindly come to.
Which judgment?
It is Miller 2022, 5 Supreme Court cases, 314. Page 314. At page 321 is paragraph 20. Well, learn it. T24 at 219.
What is the name of the parties?
Name Miller is Satyadev Bhagwat.
All right.
The state of Rajasthan.
Yes.
Huh? What the compilation?
Yes.
Okay. Only paragraph 2 minutes, only in support of my argument,
Yes.
intelligible differentia. Paragraph, it should thus be clearly seen that division bench in Jagdish Prasad, after considering the record,